Hey everyone, Fuentes here, and welcome back to the channel. Many of you tuning in today already know that I'm not only a top investor on Linqto's platform, but I was also an employee of the company. And to be clear, I became an employee after becoming a top investor on the platform. So again, not only am I a Linqto customer, but I'm a Linqto shareholder. So as you listen, keep in mind that I'm coming at this Linqto story with a unique perspective. I want the Linqto platform to succeed, and I also want the Linqto customers to win, receiving their investments on a one-to-one basis as promised. In this video, I'm going to be direct, respectful, and thorough. This is my understanding and opinion based on my recent experiences, so this is not legal or financial advice. I'm speaking up today because many of us invested through Series SPVs that were described as holding a one-to-one membership interest in specific private company shares on Linqto's platform. I've personally experienced one exit on the platform and received distributions one-for-one through Linqto Liquid Shares LLC under the SPV manager's authority. At least, that's the model we were told to expect. What we're hearing now feels a little bit different. We're hearing things like putting everything into a closed-end fund. As a customer, that's not the product I signed up for. As a shareholder, I want a solution that preserves trust, clarity, and long-term brand value. Now let's talk about SPVs, special purpose vehicles. Think of purchasing an SPV on Linqto's platform kind of like a coat check. You hand in your coat, aka your cash, to the coat room, aka Linqto, to get a claim ticket, which is the equivalent to your membership interest when purchasing the SPV. The coat room holds your specific coat, similar to how Linqto holds the underlying shares of that series under Linqto Liquid Shares LLC. If the coat room, aka Linqto, has problems, it's about process and control. It's not about changing who owns the coat, aka the claim to our underlying shares. Our primary focus should be Linqto's ledger, accounting the series by series LLCs, aka the SPVs, and making sure our underlying shares pass through on a one-to-one basis at time of a liquidity event. Now let's talk about the elephant in the room, Linqto's corporate treasury. Linqto has stated that they have a corporate treasury, often 15% and I believe even 30% of Ripple. The buffer is to maintain control and cover any potential ledger errors. Fine, but Linqto's ledger must precisely reflect who owns what series by series. Let's clear a common misconception here. Custodians like Carta and Shareworks primarily serve the issuer and the record holder, or SPV manager in our case. Custodians don't typically distribute shares directly to thousands of downstream investors. The SPV manager is usually the one who passes through the shares or cash per the series operating agreement and cap table. Even if the shares were pooled at the custodian level, Linqto's platform must maintain a clean, auditable ledger mapping each series to each investor's units. Linqto's ledger is the authoritative map here in the bankruptcy process, which is in the hands of counsel according to the most recent creditors hearing. Now, I've got two straightforward questions for the unsecured creditors committee in this Linqto bankruptcy case. Number one, what does Linqto Liquid Shares LLC actually hold as part of Linqto Inc.'s treasury versus what belongs to Linqto customers? And number two, does Linqto's ledger reconcile on a one-to-one basis with the custodian records for each series at the SPV price when sold to investors? We need checks and balances. We need series operating agreements, transparent cap tables, and custodian positions should true up down to the share. Here's why Linqto's bankruptcy case is so unusual. There isn't much precedent for a bankruptcy where customer SPV interests with a one-to-one membership claim get reframed into a new fund-like structure. Please keep in mind that the FTX debacle from a few years ago is not our analogy here. If a contract obligates share distribution at time of a liquidity event and distributions don't occur, that isn't just disappointing, that's probably going to raise legal issues. Courts decide that, not me. But as a shareholder, I'll say this plainly, keeping investor promises is the only way the brand keeps its credibility. So here's a constructive path forward. And to be clear, I'm not here to complain. I'm here to propose a workable pathway forward, one that also outlines an investor-first framework respecting the platform's future. Step one, organize series by series. Verified investors in each series must gather subscription agreements and proof of units. Elect one point person per series. Step two, audit the paper. Collect series LLC operating agreements, beneficial ownership ledgers, and proof from the custodian. Confirm proper segregation and series rights. Step 3, form a new wrapper per series. Create a replacement LLC or trust mirroring the cap table. This becomes the bridge for asset transfer. Step 4, appoint an independent fiduciary. Engage a professional SPV administrator or trustee or board-appointed investor representative with fiduciary duties to hold assets, manage distributions, file taxes, and communicate clearly. Step 5, move the assets. There's two pathways. There's the bankruptcy path, where we can ask the court to recognize each series and carve out the underlying shares to the new entity. And then there's the custodian path. Through counsel, send demand letters asserting beneficial ownership and requesting retitling to the new SPV or trust. It'll be faster if the issuer cooperates and the custodian's policies allow it. Step 6, register with the custodian. Retitle under the new entity, obtain any needed issuer consents, and ensure the fiduciary is recognized. At time of the liquidity event, the new SPV manager receives shares or cash and distributes strictly per the cap table. To make this work, we'll need distribution waterfalls clearly defined in the operating agreement. This defines how much of the fund should be distributed to each party and what the priorities are between them. For example, if you wanted the distributions in the form of the underlying shares, the operating agreement should define distributions in kind. Linqto will also need to implement new safeguards, multi-sig for transfers, clawback protection, and escrow, all of which are features available on the XRP Ledger today. And that's because the XRP Ledger was purpose-built not just for payments, but for trading, thanks to its decentralized exchange, making it the perfect, transparent, and immutable ledger for settling all forms of tokenized real-world assets, making up the internet of value. The XRP Ledger is capable of settling the entire derivatives market while supporting with corporate treasury management and even government treasury management, but that's with added layers of regulatory, scale, and policy considerations. And fun fact about the derivatives market, it's the largest financial market in the world, with notional values often quoted in the hundreds of trillions and even quadrillions of dollars, depending on how it's measured. Switching gears, here's a list of Linqto's unsecured creditors committee, representing the greater Linqto community, also represented by the law firm Brown Rudnick. The U.S. trustee, part of the Department of Justice, has an oversight role in this bankruptcy case. The U.S. trustee's office is responsible for appointing committees of unsecured creditors, among other duties, but they don't actually pick the members themselves. Regardless, what I'd like to ask the Linqto Creditors Committee to do in these turbulent times is this: reconcile Linqto's ledgers, accounting for the series SPVs to that of the custodian's positions, down to the share. Separate what is clearly Linqto's treasury holdings versus what is Linqto customer holdings. Preserve the series by series SPVs on a one-to-one basis, following suit to what was originally marketed and sold to us. I'm also asking the Creditors Committee to engage in independent SPV administrators and experienced counsel to execute a clean spin-off and recovery if needed. And lastly, to communicate openly. Fear and uncertainty shouldn't be the driver of our decisions, so keep in mind of my unique perspective and why it matters. As a customer, I want my series-specific rights respected. As a shareholder, I want a reputable, durable platform that investors trust. Those goals aren't in any conflict, they're aligned. The only sustainable way forward is a process that matches the original product that was promised to us. This is why it's imperative that I file my own claim rather than participating in any class action lawsuit. Participating in a class action lawsuit could disregard my unique position, which could supersede my claims handling efforts, impacting my claims posturing and ultimately the outcome. My final word is this: we invested on Linqto's platform with the promise of democratized private equity and on a one-to-one basis of the underlying shares or membership interests. Since the bankruptcy announcement, I've made multiple videos sharing my perspective and insights in real time. Although these times are turbulent and full of FUD, I remain optimistic that the courts, Linqto, and all parties involved in this bankruptcy process will work towards a united, investor-first resolution that also preserves the platform's reputation for the future. If you found this video helpful, share it with other Linqto investors and drop your questions in the comments below. And remember to file your claims through Epic. Thanks for tuning in. Love you mucho.